Okay, we have an appointment now, that's what it is on the agenda, with Jeff Flake of KP Law to talk about the PJ Keating license request, and this is a follow-up to the public hearing that we had, was it a week ago or 2 weeks?
2 weeks now.
2 weeks, time flies with it, 2 weeks ago. So just to brief us on that process and where we are and what we need to do next and other issues we should be thinking of.
Okay. Also, I think you've asked me out here to talk a little bit about the entire process. PJ Keating is, as you know, I guess they're wholesale moving their plant from one location on the property to the other, which, you know, in my opinion, is going to trigger more than just this flammable liquid storage tank license. But let's talk about that for a minute. As you know, under the regulations and under the statute, you have to hold a hearing. You've held a hearing. You continued the hearing to a date certain, which I believe is March 25th. You've heard evidence, and the board, after it's heard its evidence, has the opportunity, I suppose you have three options, right? You have option number one, grant the permit. Just grant it as is. Option number two, you grant with a condition. And option number three would be to deny. Let's talk about options 2 and 3, because option number 1, it's pretty easy. You just granted you're here. I think the board needs to keep in mind when they're talking about this permit, and we'll go further down the road as to other permits that may be needed by PJ Keating. But with respect to this permit, you have to have a rational basis for doing anything with a permit, being a denial or a denial with conditions. And I just want to, and I think I read this at the meeting, but I'll read it again. The Board of Selectmen have the discretion to deny or grant with conditions an application for a storage tank license. The grant of the license under 148 Section 13 is a discretionary action by the board, and a court would review the board's decision using an arbitrary or capricious standard, which means essentially you gotta have a basis in the record and the facts that were presented to you to make your determination. Courts have held that factors such as public interest, welfare, noise, traffic, and adjacent residential areas may form the basis of a board's decision to deny or grant with conditions an application under Section 13. Additional factors the board may wish to consider in this particular context of this license is explosive and inflammable, is fire and explosion hazards. Ultimately, the board will need to articulate a rational basis for its decision. So the next step for you is to continue your hearing, and based on the evidence, you have, like I said, you have the three options. I think that based on what we've heard, that I don't, and again, this is solely up to the board, but based on what we've heard, we have heard, I thought, ample evidence of the public interest. We've heard ample evidence regarding the public welfare there, noise, traffic, as it relates to the adjacent residential areas. I will just caution the board when you're making your decision that you need to constrain that to the noise, traffic, and other public safety concerns with respect to that storage tank. Now, I think at the last hearing, you heard an awful lot of residents get up and rightfully complain about other issues, the blasting, the noise, the dust. And I don't know that that was necessarily constrained necessarily to the activities of the storage tanks. So, you know, based on what you heard, I do believe you heard evidence that there will be diesel trucks that go and load these tanks, 6 to 12 trucks a day at all hours of the day that will go there, and when they offload their cargo, the flammable liquid, they sit at high idle so their PTO driven pumps can pump the liquid into the tanks. So I do believe that, you know, based on that information provided to you, that there is at least evidence of noise, of diesel fumes, I'm sure, of a number of trucks, and of what appears to be unlimited hours. So it would be up to the board. If they wanted to condition it, they could certainly condition it to try to alleviate those aspects of the application. And a denial, you would have to cite similar reasons. I will tell you, courts oftentimes will like to see if a license can be conditioned to address the interests that are impacted, would much rather see a condition than a flat denial. So that's the flammable liquid storage permit.
If we attach conditions with compliances, I assume, right? Comply to this condition, comply to that condition. Is there a period of time they have to act to comply, or are we giving them the license today and, all right, we'll give you a year when the license comes back to comply?
No,
How does that?
any license that's issued with conditions, any license, be it a food storage license, be it a food preparation, any license that's issued with conditions. If there is a violation of those conditions, you don't have to wait for next year for your renewal. You can immediately go in. Typically, the way it is you typically notify them that there's a violation.
Mm-hmm.
And typically, they will, at that point, address it or not. And then you can issue, because you're the license granting authority, and they're violating a condition, you could issue a cease and desist letter that says stop all operations until you could come into compliance with your license. If they don't, then we'll likely, either they appeal your cease and desist, or the town goes in and enforces its cease and desist.
Okay, thank you.
But no, you don't have to wait for a whole year.
Okay.
Mr. Gasper, anything?
Can I get off track about the fuel tanks, storage tanks for a minute and go to the soil?
I was going to try to kind of outline the process, and my next one up is soil board permit.
Okay. I have nothing at this time, Mr. Chairman.
I mean, I could go, I do want to, we've got a lot of comments I want to say. We've got a representative here from PJ Keating with the fire chief as well. I don't know if either of you are interested in making comments, reserving my comments till after everyone's spoken, I suppose. But Chief, did you want to add something?
Mr. Chairman, I do have one question for council. Among the conditions, the present license, land use license, is for 88,000 gallons of combustible flammable liquids, diesel, gasoline, combined.
Mm-hmm.
Does the board have the authority to either enlarge that number or reduce that number during this process?
Well, it would have to have a rational basis for doing it. It has discretion, and if they can find a rational basis based on the evidence and based on the threat to the public safety, noise, and the other factors that I've outlined, they have discretion to condition that permit.
Very good, thank you.
Anything else, Chief? A gentleman from PJ Keating, it's Doug, is it Doug?
Correct.
Doug, I'm sorry, I didn't remember the last name. Anything you want to?
No, I don't wish to add anything this time.
Okay. I mean, I'll comment. I mean, the public hearing was a bit disturbing. And I've been on the board for give or take 2.5 years, and one of the first things I latched onto, because there was a public hearing 2.5 years ago, was a hearing held by PJ Keating to move the asphalt plant to the front of the road. And from the beginning, I didn't think that was a good idea. I've expressed that to PJ Keating at every opportunity. But you know, at the public hearing and at many subsequent meetings, I mean, we heard, and I know PJ Keating is represented that they've tried to make things better, but I mean, the neighbors are not seeing the better. And the one that really jumped out at me from the public hearing was the backup, the sound of the backup on the trucks from in the middle of the night. And you know, that's one from 2.5 years ago that PJ Keating said, easy one for us to fix. We're going to put growlers on our equipment, and anybody that doesn't have a growler, we're not going to allow them to back up on the site. And just something that feels as simple as that to solve has not been solved. And after the meeting, people came up to me and said, this is an issue that continues, the sounds from that facility all night long. And the second one, you know, I went last week, Mr. DeRoche went as well, the North Fairhaven Neighborhood Association
Yes.
held a hearing. They invited, there was a representative from their Board of Selectmen, their state rep was there, residents of the town of Fairhaven also expressing a lot of concern with the truck traffic coming out of the PJ Keating facility and the volume of truck traffic, the trail of dust off the trucks as they travel through Fairhaven Village and down Alden Road. And so it's beyond an Acushnet issue, it's a Fairhaven issue. And at the first hearing I said this, and I'll say it again, I keep saying it, I believe PJ Keating has the right to operate their business in the town of Acushnet, but your right to operate your business ends at your property lines. And once you leave your property lines, you need to be respectful of your neighbors and the town of Acushnet and the town of Fairhaven, and that's really not happening. I mean, the dust, the noise, the volume of trucks is just out of control. And people that have lived on South Main Street and other areas in town that have lived there for years are just, we don't know what the volume of trucks is. I suspect you must, but just commented that their perception is it's just grown exponentially. The volume of truck traffic down South Main Street and even down Main Street in Acushnet. I guess it depends on where the trucks are going. They're actually running through the town of Acushnet and down Main Street, probably down 105 or to Wareham or wherever it is they're going. But just a huge volume of truck traffic. And again, the trucks are leaving a trail of dust and they're bouncing up and down all night long. And I think the residents of Acushnet and the residents of Fairhaven have a right to live their lives without being disturbed by the operations of PJ Keating. So as we consider the license for this facility and the renewal of your soil board permit, very honestly, the concerns of the neighbors of the facility, I take very serious. I'm very disturbed, I guess. And I think these people have been living in the shadow of PJ Keating for years and are at the point where they feel powerless to do anything about it. And I think the Board of Selectmen, and I think the Planning Board, and I think the Board of Health and the Soil Board have failed them for 30 years. And I think it's time that changes. And I think PJ Keating needs to figure out a way to be a better neighbor. Because I think the town of Acushnet needs to help them figure out a way to be a better neighbor. And we're going to do our part to help you be a better neighbor. End of my comments.
Well, that segues beautifully into my next area, and that is, so you have a flammable liquid storage permit. The next on the line would be under your soil board permit, and it's a bit of a hybrid. As you guys know, there's a soil board, but ultimately it's the Board of Selectmen that has to approve the permit. And it says, no permit for removal shall be granted unless the Board of Selectmen finds that such removal, subject to the conditions imposed by the permit, will not be contrary to the best interests of the town, and no removal operation subsequently conducted under such permit shall continue contrary to such interests. And I'm going to tell you what the interests are in a second. Quarry up there, and they're quarrying the aggregate, I believe, for the asphalt. So the two are intertwined, and I believe are legitimately under this permit. For this purpose, removal of earth material shall be considered contrary to the best interests of the town, which, 1, will be injurious or dangerous to the public health or safety, will produce noise, dust, or other effects observable at lot lines in amounts seriously objectionable or detrimental to the normal use of the adjacent property. 3, will result in transportation of materials on ways giving access to the land in question, which will cause traffic congestion or hazards. 4, will result in transportation which will cause undue injury to the roadway surfaces. 5, will result in change in topography and cover, which will be disadvantageous to the most appropriate use of the land on which the operation is conducted. Or 6, will have a material effect on the health or safety of persons living in the neighborhood in the use or on the use of amenities of adjacent land. So as you can see there, the Board of Selectmen, and it says subject conditions imposed on this permit, and the Soil Board have a tremendous amount of discretion here in determining, 1, if this permit issued would be a detriment to the public interest as it's defined here, and legitimately condition this permit to prevent those kind of injuries to the public interest. It says here, the board shall impose reasonable conditions designed to safeguard the neighborhood and the town as follows. It goes on to talk about the bare bone, the sloping of it after, but I don't believe that necessarily talks about or prohibits the Board of Selectmen and the Soil Board from imposing conditions that will make this permit so that it is not injurious to the public interest as that has been outlined in the preamble there. Section 4C talks about earth removal activities and lawful operation on any parcel at the time this bylaw is adopted may continue unless and until abandoned for more than 12 consecutive months. That would appear to be a grandfathering clause. And I think that it's reasonable to interpret this to say, if the zoning, for whatever reason, did not allow an earth removal operation on that parcel, it would be grandfathered. But nowhere in this document does it say that any grandfathered operation does not have to comply with this soil board bylaw and or permit requirements. Additionally, as we all know, things have changed. I think at one point P.J. Keating was making an argument that they were grandfathered on the site, and they very well may have been, because at that point they were no longer operating as a lawful. They were operating as a pre-existing non-conforming use. Well, we have subsequently changed our bylaw to make them a conforming use under zoning. So, to the extent that there was any grandfathering that was allowed under the zoning bylaw, that grandfathering is no longer necessary nor appropriate, because they're a conforming use and they have to conform to the bylaw. So, in my opinion, going forward, the soil board, with the approval of the Board of Selectmen, have a lot of power to, again, condition this permit to protect those interests that are outlined on Section 3 in the permit. And again, if there are no conditions that could be imposed on this permit, then in my opinion, the board could deny the permit. However, again, I have to caution you, as I did before, that courts want to see
Arbitrary and capricious.
Well, yeah, and if you can condition a permit to limit those activities or those injuries that you see, then the court's going to want you to do that. And there's one thing that I often find when I advise boards is they say, yeah, we could put X condition on this permit, but they won't follow it. So we're going to deny the permit. That's not, the fact that you don't think they'll comply with a condition is not necessarily meaning that condition couldn't address that interest. Compliance.
But just question. So, and we scheduled a follow-up public hearing on March 25th.
Yep.
Is that necessary? I'm just trying to understand
Yes.
the timeline.
Yes.
I think people got to say everything they needed to say at the first hearing. What's the purpose of the second hearing?
For you to close the public hearing, and the evidentiary portion of the public hearing, and for you to deliberate and make your
We can't
determination.
deliberate at a Board of Selectmen meeting?
No. You do.
It's gotta be a continuance of the public
It's got to be a
hearing.
continuance of the public hearing. That's why we continued it to a date certain.
All right, I was just assuming we were there listening to testimony and that we could deal with the matter that was presented at the public hearing tonight if you wanted to.
No, we want to give PJ, although PJ Keating has a close eye on our agendas and they're here tonight, but they may have other people in the audience, you did not close the evidentiary portion of that hearing, so they may want to bring in some additional evidence or make additional arguments to you before you close it, and then you you deliberate and make your determination.
Go ahead, Mr. Gasper, go.
So, Mr. Blake, you've read pretty much what I read at the public hearing as far as the bylaws, and my questions were, is what is the grandfathering clause? And we're basically being told because of the rezoning, there are no grandfather clause.
I think to the extent that they would try to claim that they're pre-existing non-conforming use, they're no longer pre-existing non-conforming use, they're conforming use, and they have to come into compliance with this bylaw and with the zoning bylaw, to the extent that there are any obligations under our zoning bylaw. There are not a lot. It's an allowed use by right in that district.
So, in the very end of the bylaw, so earth removal bylaw, it says, after the operation has proceeded 600 feet, the operator shall slope grade and reseed the initial 300 feet before or during the period when he or she begins work on the following 300 feet. Thereafter, he shall proceed in advance his operations integral distances of 300 feet while he simultaneously grades, slopes, loams, reseeds the previous integral distance of 300 feet. So what I get out of that is, if you have a 600-foot hole now, you technically should have filled 300 feet prior to going after the next 300 feet. Is that correct?
Well, I guess
Yeah, right, that doesn't really.
Yeah, I know.
the way I read it, it would be more of a, if you were going kind of this way and taking out a side of a bank, if you're going straight down, I don't know that you can fill, you can go down 600, I don't know that you can fill 300 feet and then dip down below. So the way I read that, it would be more of a situation where
That's what I'm
not
talking
a
about.
hole.
So if you have an error, well, you do technically, because you need to fill it, is what this says.
Well, as they finish the
First 300
activity, they would then have to go and reclaim it. And that would contemplate, I agree with you, it would contemplate them reclaiming as they go along. I don't know enough about the nature of the business, but if it's a hole,
It's a hole.
well, but you can't reclaim the first 300 feet of a hole and continue to dig. If it was a situation where they were removing, I've often seen gravel where they'll take literally a ridge, and they'll take the whole ridge and they'll make it flat, and they usually give it to schools and they make fields out of it. But as they were going along and they do 300 feet, if there was a bank here, you would have to reclaim that. But here, I don't know enough about the nature of the business, and that's something that would probably better be answered by a consultant that we may have.
So if we're thinking about conditions on the license, the process to put those conditions on the license, we could certainly get our arms around what those might be prior to the next hearing on, it's actually the 24th of March, right? We could figure out what we want those conditions to be.
You could figure out what you want those conditions, you could deliberate about those.
And we could do that as a Board of Selectmen?
No.
No.
No. You can't do anything with that permit request. Here we're talking about the overall,
Process, yeah.
what's going on. But that's best left during the public hearing process. Now, certainly, you, as an individual board member, can think about the evidence that you've seen and think about a condition that you may or may not want to put on there.
I guess so.
And you can deliberate with your board members during that night, and if you decide that you want to deliberate again, you could continue the meeting again,
But it's got to be as a continuation of that public.
out in the public. The public and the applicant have the right to be here and listen to what you're saying and how you're deliberating.
But, I mean, we posted this meeting with an agenda that says we're talking about it too, but that doesn't, it's different. Okay, I'm just trying to understand.
Yep.
Okay.
Okay.
Gentlemen? Anything else, gentlemen?
Not at the present time.
Chief,
Not-
anything?
Not at this time.
Doug, I'm sorry, last one, Doug,
Vino. Vino, V as in Victor, I-G-N-E-A-U. Vino.
thank you, Doug, thank
You're
you.
welcome.
Anything to add, Mr. Vigna?
No, sir.
No, okay, thank you.
Okay, so number 3.
There's more.
Yeah, and wait, there's
But
more.
wait, there's more.
As I
That was
said,
option 2.
as I sat through the public hearing the other night, I saw a lot of people, a lot of neighbors get up and have a lot of issues. Most of them talked about dust, about traffic, about the backup noise. And again, under your soil permit, I believe that that's something that could be conditioned. And frankly, I think it could be a legitimate condition with respect to certainly the trucks that are loading the flammable storage tanks to have the, you call them growlers, the backup, the white noise backup rather than the beep, 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 beep. But I heard what I thought were a lot of claims of nuisance. And the Board of Health has extraordinarily broad discretion in addressing nuisances. The blowing of dust, the noise at night, possibly constant banging of trucks, lights that shine into neighborhoods, those are all nuisances and are legitimately regulated by the Board of Health. The Board of Health, I believe, has a nuisance abatement plan, or at least I think we reviewed one of those. And they can certainly enforce that nuisance abatement plan. And again, because they may or may not have been doing that, when the facility was a mile back, we all know that the facility is now going to be front and center with the residential neighborhoods, and there's just gonna be more of a conflict. And that would be the third way of addressing these.
Through the Board of Health.
Through the Board of Health,
Board of Health's
addressing,
very engaged in this.
addressing these neighbors' concerns. It's not as, well, they have the ability to identify the nuisance, they have the ability to send out a cease and desist letter, telling PJ Keating that they are creating a public nuisance. PJ Keating can then come in, talk with them, or not, and if they continue to create the nuisance, the Board of Health then can take action to force them to abate the nuisance.
Okay.
So, those are the kind of the three broad jurisdictions. The Board of Selectmen are at least in two of the rings.
Anything else, Attorney Blake?
I don't have anything, but certainly if you guys have additional questions or comments.
No, this time I'm all set.
Ms. Hebert, anything? Okay. No?
Can,
No?
I forgot the guy's name.
Mr. Vigo?
Doug?
Vino.
Can I call you Doug? Mr. Vino? Can I ask you a question?
You can ask.
That's fair.
The question that I have is, why didn't PJ Keating come to the Board of Selectmen and engage with the Board of Selectmen before you took the initiative to move that asphalt facility?
I wasn't working at PJ Keating at the time.
Okay, fair enough.
Okay, so
Yep.
let's move on.